Good morning, everybody, and thank you all for coming to the Today's Restaurant News Networking Group. My name is Howard Appel. I'm the founder and publisher of Today's Restaurant News, and we are a group of vendors who are here to help each other grow our businesses and also to help any restaurant owner, manager, or chef who might have a question or a concern that they need to get answered. They are welcome to give us a call at 561-620-8888 or go to our website at trnusa.com and check out our YouTube channel, which is also easily accessed on our website at trnusa.com. And there's a link there that'll take you right to the YouTube channel. So good morning, everybody, officially. As you all know, today we have a guest speaker, Elliot Brown. I'm just going to give you a little bio on Elliot, and then I'll let him take over. So Elliot brings over 40 years of experience as both an in-house general counsel for various companies, as well as serving in the corporate departments of law firms in Tel Aviv and New York. Elliot's experiences include 10 years as vice president and general counsel at a U.S.-based subsidiary of an Italian holding company with various holdings in the sporting goods and accessories industry. Elliot also served as the senior vice president and general counsel at a full-scale global fashion and lifestyle company, most famously known for their hip-hop and streetwear clothing lines. Elliot's duties as general counsel include managing the company's vast trademark portfolio, as well as anti-counterfeiting efforts on a global basis. Elliot has since put his experiences and knowledge to work for his clients, representing international clothing and lifestyle brands, celebrities, entertainers, and people in networking groups. And I'd like to turn the meeting over to Elliot, and thank you very much for coming. And you're able to share the screen.
Right. That was going to be my question. Thank you. So let's, oops. Okay. Okay. Okay, everybody can see the PowerPoint?
Nope.
Not yet.
Nope.
Okay. That's not good.
Nowhere in the intro did it say you were a computer expert, right?
So I'm clicking share screen.
Where's Darren? Help him out, Darren.
Howard, do you have your share screen on?
Yeah, once you share the screen, Elliot, then you got to click whether you want to share a particular window or your entire screen.
Yeah, mine is clicked.
Okay.
Guess we should have rehearsed this part. So Darren.
Yes. So you go down, you hit the share icon.
Yeah, I did that.
Which should be green. And then it should pop up a window that shows you can pick which part of your screen you want to share, whether it's a single app or you can just share the entire screen.
Okay, I click on share screen.
Mm-hmm.
Then where am I going? Where's this share?
Yeah, where it says, there you go.
Well,
you got
it. Okay.
There you go.
And then just click there, got it.
Okay. Wow, I built up a sweat on that.
Let me start all over again.
No.
Go ahead.
So good morning, everybody. It's great to be here. Just to pick up where Howard left off as far as my bio goes, I pretty much covered my professional career through 2009. At that point, I left a New York law firm. I was living in central New Jersey, although born and raised in Miami. I lived for approximately 35 years in the central New Jersey area and worked primarily in New York City, as Howard mentioned, both as in-house counsel, general counsel, but also for law firms. I left the last of the law firms I was associated with in 2009 to begin my own practice, which was originally called Law Office of Elliott J. Brown. As of January 1st of 2023, I entered into a partnership with my colleague, Adam Blyer. And as you can see on this opening screen, the name of the firm is Brown and Blyer PC. I still indicate our main office address in Marlborough, New Jersey. I'm speaking with you from my home office in beautiful Boynton Beach. So we operate from both locations. At Howard's request, I'm going to share with you in broad strokes primarily an overview, first of all, an overview of different types of intellectual property. And then I'm going to drill down and spend most of the presentation on trademarks for two reasons. One, I thought that the trademark world might be the most relevant to the restaurant industry, as well as other industries any of you may be involved in. And secondly, quite frankly, I find it more interesting. One thing I wanted to mention in addition is that we are not merely intellectual property attorneys. Brown and Blyer is a business transactional firm, and the bulk of our work is providing advice and negotiating contracts of all different types on behalf of our clients, which range from sole proprietors, partners, LLCs, corporations, all the way up to multinational companies. And we are engaged in all types of business deals, whether it be bringing together new people who want to start a venture, to the purchase or sale of businesses and everything in between. So that's by way of background. Now let me jump into intellectual property. Basically, when one speaks of intellectual property, or IP for short, we're talking about the following areas of the law. Patents, which include both utility patents and design patents, copyrights, trademarks, trade dress, and trade secrets. These are all different ways in which an individual or a business can protect what is either confidential or proprietary to them. And we'll get into how one does that and how one can enforce their rights in these various areas. I'm going to start with the first one that requires absolutely no cost to third parties. In other words, you don't have to pay anybody else to protect your trade secrets. And as you can see, trade secrets are basically the information that is confidential and proprietary to the business. It must be information that is used in the business and provides an economic advantage over competitors who do not know or use it. How do you protect trade secrets? Basically, you protect trade secrets by not disclosing the information unless you do so in a certain manner, which I'll get into in a moment. Trade secrets have been codified. And when I use the word codified, it means basically that each of the 50 states have adopted some form of trade secret act. In Florida, for example, it's called the Florida Uniform Trade Secrets Act. So there is a statute that describes what a trade secret is and how it may be protected and how one may go about enforcing it, and what are the possible remedies that may be available to you if you do need to enforce it. You can see the word enjoining there. Enjoining means you go to the court to obtain an injunction. to stop somebody from doing something or to require them to do something that they're supposed to do and aren't doing. So you can get injunctive relief or you can get damages if the violation of the trade secret actually damages your business. So you can also lose the trade secret. You lose it by disclosure. So if the business owner or somebody acting on behalf of the business owner discloses the information to the public, or the public otherwise becomes aware of the information through no fault of a party, then that party is protected because it's no longer confidential information. They do not expire unless one of those events occur. And what's the best way to protect it? If you're going to need to disclose that confidential or proprietary information to a third party, then the best and easiest way to protect your confidential information, your trade secret, is to have that party sign an NDA, a non-disclosure agreement, as a precondition to receiving that information. So again, this is a basic protectable right. It doesn't cost you any money as far as paying a government agency to file any type of documentation, and it's provided under law, both under common law as well as codified, as I mentioned, by various statutes. I'll take a second just because you're going to hear me mention common law a couple of times. Common law is basically the law that developed over time in those countries, including the United States, that at one time were owned or controlled by Great Britain. So under the British system of law, certain aspects were developed to protect one. And when the United States became an independent country, Canada, Australia, etc., we follow the common law. The countries of continental Europe, Spain, France, Germany, the Netherlands, etc., their laws came out of the Napoleonic laws and are typically referred to as civil law countries. So those countries and any country that they owned or controlled, such as the various South American countries that were owned or controlled by Spain or Portugal, they follow the civil law. The next area I want to touch on, again, that does not require any type of filing with a government agency to protect it, is trade dress. This is probably, of all the ones I'm going to speak of, the one that's least known, but trade dress is a concept that developed out of protecting a product's design, its packaging, its non-functional elements that make it unique. So I'm going to show you a few examples of what we refer to as trade dress. Probably the most famous one is the iconic Coca-Cola bottle. And so it's not the words Coca-Cola, but it's the actual shape and design of the bottle itself that is protectable as trade dress. In other words, even if you didn't see the words Coca-Cola on that bottle, but you just saw the bottle, even an empty bottle by itself that looked like that, you would associate that bottle with the Coca-Cola company, and that is a protectable trade dress. Another one, various patterns and designs. Again, this bag, by just looking at the bag, you don't see the name of the brand anywhere on the bag, but the design and colors and combination thereof is protectable trade dress. It expands even beyond that. There was a famous case in which a Mexican restaurant had developed a particular design scheme for the interior of its restaurants. A competitor developed something similar, and they were sued for trade dress infringement, and the original restaurant won that suit. Okay, I'm now going to speak on the types of intellectual property that are more commonly discussed, but there's a lot of confusion in the terminology. And I'll say that even many of my law colleagues will often confuse the words patents, trademarks, and copyrights. So hopefully by the end of this presentation, you'll have a good understanding of what is a patent, what is a copyright, and what is a trademark. So patents, as mentioned earlier, are divided into two types: utility patents and design patents. And the easiest way to think of a patent is the protection given to an invention. And the invention must be novel and it must not be obvious. And the utility patent, as I mentioned here, addresses the functionality of the invention. So you're the first one who developed a brand new way to do something. It's the function of that product that you've designed that could be potentially patentable as a utility patent. On the other hand, a design patent, while also needing to be novel and non-obvious, addresses the design, the look of the object as opposed to its functionality. And in fact, if you try to protect its functionality, you will not be able to obtain a design patent for that particular product. You may be able to get a utility patent, and the two are not mutually exclusive. One could obtain both a utility patent and a design patent addressing functionality versus design. Of the three types of intellectual property that one must involve a governmental agency. Well, I'll take that back. When copyrights, you don't have to. We'll get into that in a second. But again, to get the fullest degree of protection, you have to involve a governmental agency. In this case, it's the U.S. Trademark and Patent Office, also known as the USPTO. You'll see I use that phrase. Of the three, meaning patents, copyrights, and trademarks, patents are the most expensive. It could easily run tens of thousands of dollars, if not more, to obtain a patent, assuming that you're successful in doing so. The patent, when issued, it's valid for 20 years from the date the application is filed. So, for example, pharmaceutical companies often find themselves trying to obtain a patent. It could take 5, 6, 7 years to finally get that patent issued. Well, once it's issued, they only have another 13, 14, 15 years of protection because the period of enforcement relates back to the date the application was filed as opposed to when it's issued. Although some protection is available while the patent is pending, and you can get a little bit of a marketing plug by indicating that a patent is pending, kind of put the competition on notice. Hey, better be careful before you start using what we claim is a patentable product, because we're eventually going to get a patent and we just put you on notice. Okay, so the two areas that I think are probably going to be more relevant for this group are copyrights and trademarks. Copyright came out of the common law to protect works of authorship, whether they be literary, dramatic, photographic, video, musical, or artistic. When did the concept of copyright develop? It developed with the invention of the printing press. Prior to that, if you wanted a document to be reproduced, one would have to sit there and do so by hand. So you think of, many documents that go back hundreds of years. They had to be reproduced by hand. The development of the printing press changed that and made it much easier to reproduce that written material. And of course, it grew out of written material, but as mentioned in the first bullet point, it covers basically anything that an author publishes. So again, it could be a photo, it could be video, it could be a television show, a movie, etc. The copyright protection generally extends for the life of the author plus another 70 years following the author's death. But if it's owned by a company, companies don't die, so there's other aspects to that. It's automatic under common law. It's automatic from the time the work is created. So you as an author, write something, that is yours. You are the author. You're not copying somebody else's work. And from the moment that is published, you own the copyright on it. Recently, within the last several years, the US said you no longer need to include a copyright notice, but we think that it's always a good idea to do so. And I've shown you two examples, right? The copyright symbol or the word copyright spelled out, followed by the name of the author. And often you'll see all rights reserved. If you watch a movie, a TV show, an NFL football game, what have you, you typically will see the copyright notice, if you pay attention, at the very end of that broadcast. Now, having said that, you have automatic protection under common law. You will get enhanced protection if you record or register that copyright at the US Copyright Office. Of the three different types of IP that where we get a government agency involved, copyright is the least expensive. In fact, it's very inexpensive. It could be as little as $50 to file to record a copyright. That amount is going to vary depending on the type of work and other aspects, but it could be as little as around $50. And by recording it with the Copyright Office, you will get enhanced protection in the way of possibly recovering what are known as statutory damages, as well as potentially recovering attorney's fees from the infringer. So how do you, if you want to enforce a copyright, you can obtain injunctive relief. For example, going back to what I said, where the court orders somebody to do something or stop doing something. If you've seen in the news as recently as the last couple of days, a court, I believe in Georgia, issued what's known as a preliminary injunction enjoining the Donald Trump campaign from using a song that Isaac Hayes wrote, and his estate. Trump did not have permission from the estate, didn't have a license from the estate. The estate sued and obtained the injunction so the Trump campaign may no longer use the song Hold On, I'm Coming. And you also, as I mentioned earlier, can potentially get monetary damages if the infringement resulted in monetary damages to the owner of the copyright. And I added this bullet point, no 30% rule. Over time, representing companies in the fashion industry, I often would have to work with, not have to, but had the pleasure of working with people in the graphic design department. And on more than one occasion, I would say to somebody, you can't just grab somebody else's work and then make it your own. And they said, well, I learned that if you change it by at least 30%, then you're not infringing. And I had to explain to them that no, there is no such rule. It all comes down to the overall look and feel of the work. So you might change it 20%, but those 20% changes were dramatic enough to move it away from the copyrighted work. Or you might change it 70% and it wasn't enough. So it has nothing to do with a hard and fast percentage. It's more how much does your work resemble the copyrighted work. I was just contacted within the last couple of weeks by a new client who was sued. Well, actually, the suit wasn't filed. They received a cease and desist letter from a company that basically trolls the internet looking for anybody that lifted without permission a copyrighted work. This new client is a very, very small Tai Chi, what do you call Tai Chi studio, for lack of a better word coming to mind, that the person in charge of marketing lifted a photo off the internet, used it as part of their marketing materials. And one of these companies that are constantly monitoring the internet saw that use and demanded a payment of a few $1,000s for this one-time use by this very, very small company that basically can't afford what they're being demanded to pay. So one needs to be very careful about what one uses. Again, my colleagues in the fashion industry would often talk about being inspired by something. And I said, well, that's great. You can be inspired, but just make sure that the end product does not resemble the copyrighted work. So that's basically, in a nutshell, the world of copyright. Fair use. There are exceptions. I'll just mention very briefly that one may use a limited amount of the copyrighted material if it's for commentary, criticism, news reporting, or scholarly reports. Again, always be careful because if one is going to rely on the fair use doctrine to avoid an infringement action, just make sure you get. My suggestion would be to get legal advice before using it. Okay, what is a trademark? A trademark is a word, a phrase, a symbol, a design, a combination thereof. Identifies and distinguishes the source of the goods of one party from those of others. There's a very big distinction of what a trademark is for legal purposes versus marketing purposes. And this definition that I just gave you is the legal definition. Basically, how I explain it to when I'm mentioning trademarks is that the purpose of the trademark for the consumer is so that the consumer knows that when they see that name, that brand, that identifier, they know the source of those goods or services. When you, going back to that Coca-Cola bottle we looked at, right? So now I'm focusing on the words Coca-Cola. When you look at that name, you know that that product came from the Coca-Cola company or an authorized licensee or distributor of the Coca-Cola company, as opposed to the marketing aspects of the name. Even colors or sounds can be registered trademarks. Color pink for fiberglass, owned by Owens Corning, or the dun dun dun, pardon my singing, is those chimes is owned by NBC as a registered trademark. Even smells can be registered, although I've never tried to register a trademark for a smell. Okay, so when most people think about the trademark, it's the company's brand. While not required in the US, and again, this goes back to common law, registering the trademark does provide greater protection and enhanced damages if infringed, similar to what I mentioned with respect to copyrights. So again, under our common law, I develop a particular brand, I start using it, I automatically have rights to that name, to that mark, even if I haven't registered, although of course I always recommend registration if it's available. Trademarks are issued by international class. This is by a treaty in which practically every country in the world is a party. It's called the Nice Convention. And it's divided into a total of 45 classes. 1 through 34 cover goods, and classes 35 through 45 cover services. So the more unique the word or phrase, the more likely it's going to be available for registration. I love to use the word Xerox as an example of a great, unique word because the company, the Xerox Corporation, made that word up. You're not going to, you wouldn't find it in the dictionary unless, the dictionary is, using it to identify the company or the brand. But it's a totally made up word. And therefore, those are the easiest ones to obtain registration. The flip side of that is that when a name becomes too popular, it then runs the risk of becoming genericized. And so companies like Xerox had to stop people from using the word Xerox as a noun or a verb. Please go Xerox these documents for me, because if you let people do that too much, you could potentially lose the trademark protection. In my past life, as general counsel, one of the brands that we owned was the brand Rollerblade. I would have to send out letters to people saying, please don't use the word rollerblade as a noun, or rollerblading as a verb. You'd see signs put up in public parks, no rollerblading permitted. Well, if you allow that to continue without trying to stop people from doing that, again, the word could become genericized and you could lose your trademark protection. Going back to where I was here, I've dealt, as Howard mentioned, a lot in the fashion industry. Class 25 covers clothing, and it's very difficult to find a name that has not already been used by somebody else in connection with clothing. So that's becomes a big challenge for my clients that want to register marks for clothing. And as I mentioned here, before actually applying for the trademark, a search should be performed to make sure that the name is available, because it will be rejected if there are other names, a name or other names already been used for that particular class of goods or related class of goods. Okay, so in the US, to obtain that trademark registration, the mark must be, and the legal term is used in commerce, meaning that there are either actual sales of products or performance of services under the trademark. That use does not have to begin before you apply for the trademark, and I'll get into a little bit more detail on that when we get into the process. But to get it across the finish line and obtain that registration, it must be actually used in commerce. And then once you get the registration, you can get a renewal after 5 years if that use is continuing, and additional 10-year renewals after the 10th year. Trademark registrations are national in scope. So if you get the trademark registered in the US, you're protected in the US, but you're not protected in Canada, any other country, unless you file a separate application and obtain a registration in that country. The only exception is if you get a registration in the European Union, that registration will cover all 27 countries included in the EU. Until Brexit, it used to be 28, but now you have to file and obtain a separate registration for the UK. And I just threw on here some of the more famous trademarks. And as I kind of scroll through these, I'll mention that in addition to just showing them, I'm also want to point out the different types. The ones on this page in the middle are what we call word marks. So just the word itself is protected. Again, in that class or classes that covers the particular products or services. And I'll just mention now that, again, using my experience in the fashion industry, a company that sells clothing often will sell related products. They may sell bags and accessories. When we say accessories, meaning bags, backpacks, luggage, things like that. They may sell sunglasses or other eyewear. They may sell fragrances or other cosmetic products. Each one of those things that I mentioned would require a separate application and registration in the class that covers those. So I mentioned earlier class 25 for clothing, Class 18 covers the bags and related accessories. Class 9 covers the sunglasses, and Class 3 covers the cosmetic and fragrance products. So if one wanted to protect the name in all of those classes, you would have to file and obtain registrations in all four that I just mentioned. So again, going back to the slide, the middle, the names, the Champ Life, Champ Camp, Jersey Free, Sex Tape, etc. Those are we refer to as word marks. The the Party Perfect, Evil Fades, Himalayan Delighted, and City Master Barbers. Well, they are actually composite marks because they're combining both the name of the brand together with a design. Some others, if I draw your attention to cookies, I wanted to show the three different registered trademarks for cookies. This is, again, one of those lifestyle brands that I represent. On the left, the word cookies in solid capitalized letters is the word mark. The one to the right in script is a design mark that it's the exact same word, which arguably would have been protected by the word mark, but kind of the old belt and suspenders, we wanted to make sure we had it protected in all manners in which the client uses it. And the one in the middle, which we refer to as the C Byte logo, that's the associated design mark. So it's kind of like Nike, that's like Nike swoosh for cookies. That C Byte logo is kind of like their swoosh. And again, I just wanted to show different variations of registered trademarks that reflect design marks, word marks, and composite marks. So how do we go about registering a trademark? Well, again, if you come to Brown and Blyer, we would first want to analyze that the proposed trademark meets the legal qualifications to act as a trademark and be registered. And without going into too much detail, the ones that I'll get into the likelihood of confusion in the next couple, but this bullet point also is meant to cover the concept of descriptiveness. You cannot obtain a trademark registration if the proposed name, and the legal words are, merely describes the characteristics of the goods or services. So, we've run into issues sometimes with the trademark examiner who says, no, you can't get that trademark registered because it's merely descriptive, and then we have to argue with the trademark examiner. Next, we run an availability search. We always recommend to our clients that they authorize us to use a third-party search firm, while we ourselves can look at the USPTO database to see what's on the database. Third-party search firms use algorithms that give a much broader search capability, and we get sometimes 50-page reports that we then have to go through to make sure that the trademark is available for registration from a likelihood of confusion standpoint. In other words, to make sure that the proposed mark does not infringe or come too close to either a mark that's already registered or that was applied for before we file our application. And then the third point is to discuss with the client whether the trademark is already in use to determine the filing basis. And I alluded to this a little bit earlier. So in the US, we can file a trademark application on one of two bases. One is I'm already using that trademark in commerce, and now I just want to make sure I get that enhanced protection by registering it. The other is I'm a brand new business or I'm a brand new business and I intend to use this particular name to describe my products or services, but I'm not in business yet. We can file the application now to preserve our spot in line on what's known as on an intent to use basis. But as I mentioned earlier, while we can start the process and move the process along, we can't get it over the finish line and obtain that registration until the client is actually using the trademark in commerce. So we go through that analysis with the client, and then we prepare one or more applications to register the trademark. And it's going to depend on the number of classes, as I touched on earlier, in which the protection is desired, as well as the type of application, whether it's based on use or an intent to use. We send the application to the client. All this is done electronically these days. It's amazing. The client then reviews and electronically signs the application. It's returned to our office electronically, and then we submit the application to the USPTO, and we pay the applicable filing fee on behalf of the client. Unfortunately, and I don't know if this is directly related to COVID or not, but it's now taking on average 6 to 9 months before an application is even assigned to an examiner. Back in the good old days, it was typically 3 months or so, 3-4 months tops. And if everything worked as we would hope, we would get that registration typically in a year or less. Now we're telling clients 6 to 9 months to be assigned to an examiner, 18 months to 2 years to get that registration. But again, you're ahead of everybody else once your application is filed. So the application is filed. The examiner who's assigned to it first checks to make sure that it meets all legal and technical requirements. And that goes to what I mentioned earlier, that it's not merely descriptive and other filing requirements are met, and that it does not conflict with an existing registration or a pending application in a, quote, likelihood of confusion analysis. I'll just mention now, trademark examiners, they are attorneys, but like all of us, everyone has a subjective viewpoint on things, including whether or not there's a likelihood of confusion between the trademark that we're applying for and one that's already been registered or was applied for before we applied for ours. Again, you could put the same application before 2 different examiners, and sometimes it's just a luck of the draw as to whether your examiner believes there's a problem with it or not. If the examiner has no objections, then the application is published for potential opposition by third parties, and they're given 30 days to do that. What does that mean? The examiner went through it. The examiner had no issues with it, but the public is given a 30-day period from the time it's published in what's known as the official gazette to say, all right, the examiner didn't think there's an issue, but I do. And you can either immediately file an opposition. This is a quasi-litigation in the special appeals part of the trademark office. Or you could request an extension of time to file an opposition, basically freezing that 30 days, and then you can further extend for a total of 90 days, at which time you can contact the applicant and say, hey, you might not be aware of this, but we've been using this trademark in commerce for X number of years, and you would be infringing it. So, please withdraw your application. If the other party, the applicant, refuses, then you then have a choice as to whether or not to file that opposition. Unfortunately, opposition proceedings can become very costly. They can be easily go into the tens of thousands of dollars because they are a form of litigation. And so, again, that's why we emphasize the need to search and clear names before we go to the trouble of applying for it. The client could potentially be spending a fair amount of money investing in that brand only to be told later on that they can no longer use it. If the examiner believes that there are reasons to refuse the registration, the examiner issues what's known as an office action, telling the applicant why the examiner believes the application should not go through. And then if and when we get an opposition, we then address the examiner's objections. We pride ourselves in, more times than not, being able to overcome the objections. Sometimes the objections are relatively simple and technical in nature. The worst objection to get, of course, is that likelihood of confusion objection, because then we have to argue with the examiner as to why we believe it's not going to cause confusion with the consuming public. And again, hopefully we overcome the objection. If we do, the application then moves forward to publication, which I covered a moment ago. A little bit of a different path is that if the application was filed on an intent to use basis, as I mentioned earlier, to get it across the finish line, you have to demonstrate use, and there's a process for doing so, and it adds a little bit of extra cost. This is what we're trying to achieve. This is a actual trademark registration certificate for one of our clients, Molino's, for restaurant services. Molino's is an Italian restaurant and pizzeria based in Manalapan, New Jersey, with a second location. And you can see the first use, if you can read it. They've been in business and first started using the Molino's name back in July of 2010. So this registration not only was issued in 2016, but was renewed once and will be up for another renewal in 2026. So what's it cost, Elliot? All right, well, basically on a per mark per class basis. So in other words, you would have to multiply what I'm showing you times 2, times 3, times 4, etc., depending on the number of classes. The search with the third-party search firm runs about $150. Our current cost for our time to prepare and file the application and provide the advice that we give our clients. This is one of the few things we do on a flat fee basis for $850 currently. And then the USPTO filing fee is either $250 or $350 per mark per class, depending on how the application is filed. And there's a little too much detail to go into that right now. But of course, if we can save the client $100, we try to do so. So the total cost, add those three things up, is roughly $1,250 to $1,350 per mark per class. And as I mentioned, on the back end, for an intent to use application, there might be another $400 to $500 of cost. There's an additional filing fee to pay, and of course, our time to prepare and file the necessary documents. Once the registration issues, it's good for 5 years. If you want to renew it after that initial 5-year period, you must file documentation showing that the trademark is still being used in commerce. And it also, at that time, you have the opportunity, it's not required, but we always recommend that we do so, is to make the registration what's known as incontestable, which basically means that, as we discussed earlier about oppositions, there's also another concept of canceling an existing registration. Well, the incontestable registration may not be canceled by a third party unless that third party is able to show that it was originally obtained through fraud on the PTO, which of course is a very difficult thing to do. So it basically makes it non-cancelable. And that cost is currently $850 per mark per class at the 5-year mark, between our flat fee and the USPTO filing fee. And then after that first 5-year registration, the registration becomes renewable every 10 years, again, as long as the mark is used in commerce. And these renewals can be indefinite as long as there's continued use. So, very famous marks that have been around for 80, 100 years. I think as long as they're still being used, they can continuously be renewed. Trademarks, like any other asset, they can be sold, especially as part of the sale of a business. The right to use a trademark may also be subject to a license, potentially earning the trademark owner royalties if it's a valuable mark that other parties want to use. Or in certain cases, again, going back to some of my prior clients, or even a current client, let's say the client is involved in the manufacturing sale of one type of product, but the mark is now famous and could branch out into other types of products, then you have the potential opportunity to offer licenses. So, for example, that clothing brand may be licensed to a watch manufacturer. My clothing client knows absolutely nothing about manufacturing watches, so licenses the name to the watch manufacturer who makes and sells watches and pays the trademark owner a royalty. It also works geographically, where, again, if our mark is famous in the US, there may be people in other countries that we don't sell in that might be interested in taking a license to sell in those countries and pay the trademark owner a royalty. Franchises, I don't know of any franchises that do not operate based on a registered trademark. I think it would be too much of a risk for one to enter into a franchise arrangement if the trademark is not registered. We face challenges sometimes regarding infringement and or counterfeiting. You can enforce your trademark rights as well as copyright rights, both criminally and or civilly. Civilly meaning, sue for damages. Criminally meaning you get a law enforcement agency, whether it be local, state, or federal, involved. And a very inexpensive enforcement method is to take your registered trademark and record it with US Customs. And if they happen to open a shipment that shows your product in that shipment is being counterfeited, then they will contact the trademark owner or me, and we will confirm that the product is counterfeit, and they will seize it, hold it, and eventually destroy it. And then, of course, we get the information where we may pursue the infringer if it seems to make economic sense to do so. And that's the end of my presentation. I don't know what your format is, if you open it up to questions, Howard, or if I talk too long.
Well, no. Well, I want to thank you very much for a very informative and informational presentation. If anybody has any questions, give me my screen back, Elliot. We can do that. There
Yes,
we go.
sir.
If anybody has any questions for Elliot, Ed, I'm going to go as I see you on the board. Ed, you have a question?
Yeah, Elliot, question for you. How does all this trademark work with everything coming over from China, where supposedly there's trademarks on everything, and they bring over everything in trademarks and saying it's not trademarked? I don't understand that.
Okay, well, it's a real conundrum, right? I mean, the more popular your brand becomes, the more likely it's going to face counterfeiting. So in our case, we will go. It's next to impossible to stop it in China. Even the largest brands, and I used to work with attorneys that represented, the top brands in the industry, and even they struggle when it comes to trying to shut it off in China. We're more successful in going after the folks that are importing it. So as I mentioned towards the end of the presentation, if we become aware that the product is coming in, let's say, we get from customs a notification that they just seized 10,000 pieces that were being imported by such and such. I bring that to the client, and if the client agrees, we can then bring an enforcement action against the importer. And then sometimes they're even, you can go up the chain, where if you see it at retail and it's counterfeit, let's say you see product being offered for sale in a convenience store, and that it's got to be counterfeit because our client doesn't sell to convenience stores, and it's cheap, and the quality is terrible, and what have you. Well, you go after the retailer, and you try to get the retailer to provide you with the information as to where they sourced it, and you try to go up the chain. But it's sometimes the little boy trying to plug holes in the dike. It's not always easy.
Okay. Is that okay, Ed? Did that answer your question?
I guess
Rob,
so. I mean,
Rob, you had a question?
Yeah, Elliot, first of all, it's very extremely thorough. I mean, I learned so much. But
I'm sorry, folks. I'm sorry. Just 1 second, please.
yeah,
This person's being very persistent. Okay.
yeah,
Yes.
I learned so much. It was very thorough. But I'm just curious, now with all these kinds of hacks that are on the internet, especially with cybersecurity and all this kind of stuff, what's troubling me, you said that, the application process takes like 6 to 9 months. How do you protect yourself within that period of time if, let's say, somebody's out there?
All right. So first of all, just to correct one thing you said, unfortunately, I wish the process was only 6 to 9 months. It's 6 to 9 months before an examiner is even assigned to your file.
Oh,
It's
God.
now running 18 to 24 months typically, and that's assuming no office actions. That's assuming everything goes smoothly. How do you protect yourself? Well, again, you have common law rights to the name, to the brand, and we would send a cease and desist letter to the infringer, telling the infringer that we have superior rights to them, that they're infringing, and they should stop. If they don't stop, again, depending on, it's a cost benefit analysis, like practically everything. That I apologize. That one has to weigh the cost of litigation against the potential benefit, and make a business decision as to whether the the benefits outweigh the cost. We would typically start out with a cease and desist letter, saying, we have rights in this name. You're infringing. Please stop. And depending on the response or lack thereof, then it's up to the client as to what they want to do.
Okay. Any other questions? Azalea.
Elliot, I was just wondering what happens to things that are outdoors? Like if I walk by a street and I see life is beautiful and a pretty sun, I take a picture and I make postcards and a t-shirt and a canvas bag and I sell it. Does that belong to anybody? I mean, it says I love life and it's a sun, like something generic, or even if it's a pretty mural and it's not signed, but clearly it's like artistic, made by somebody. What are the rules with things that are just out in the open?
This is annoying. So, in all likelihood, we're talking about copyright. I didn't get into all of the details about copyright. Uh, as so again, the author, the artist, the publisher of that mural, for example, and I think the mural is probably a better, easier example to address than just seeing a sign that says "Life is beautiful."
Okay.
That artist has a copyright in the artwork. Now, if you are walking by as an individual and you see it and you snap a picture of it because you thought it was beautiful and you just wanted it for your own personal use, that's not going to be an issue. But if you then take that picture of that mural, and you start using it for commercial gain, that's then when it becomes an infringement. Your Life is Beautiful, take the picture of the poster thing, is probably a little more difficult of an analysis. Again, if it's for commercial gain, then you're giving the people that created it more of a argument that you're infringing. Again, a phrase like "life is beautiful," whether or not that's registered as a trademark, again, that's going to depend on what's out there already and for what goods or services it's being associated with, right? So, that's a little bit more of a tougher call.
Thank you.
Any other question? All right, again, Helen.
How would you know in the case that Azalea talked about that you were infringing on someone's rights?
Well, again, what's the motivation? I would
I mean,
start
if
with
you
what is,
did say you saw something like that and you took the picture and decided to sell the picture, the videos, whatever it is, how do you know that you're infringing on them?
well, I would first go to an attorney and say, please search this to see if it's registered as a trademark. And
Mhm.
if so, for what goods or services?
Right.
Now, interesting enough, and again, if we could spend hours on these topics, and even like I said earlier, a lot of lawyers don't even understand this world. Interesting enough, you as the photographer who took that picture now own a copyright in the picture. Okay, so if you could then stop others from using the picture as the copyright owner. Being the copyright owner of that picture does not necessarily defend you from a trademark infringement case if that phrase is registered. So that was a good example.
That
Very
makes,
interesting.
Okay. Again, Elliot, I want to thank you for coming and giving us this in-depth explanation of the points that we were talking about. And again, thank you very much.
My pleasure, Howard. And of course, if anybody thinks of anything after this that you want to address, I guess will my information be out there as well, Howard?
Why don't you tell us how we can reach you?
yes.
Okay. So I guess the easiest way is by email. My email address is ebrown@brown, the word and spelled out, A-N-D, Blaier, B as in boy, LAIER.com. The second easiest way is to ask Howard.
Okay, great.
You will have his information in the spreadsheet. Is that correct?
Right.
Yes, Elliot, to answer your question, it will be in.
Okay.
All right, I want to get to our intros, and I want to introduce the new people that are here in particular. I want to start out with Joanne. If you could, Joanne, tell us who you are, what you do, where you're located, and how we can reach you.
Yeah, so can everyone hear me?
Yes. Yes. Good.
Okay, excellent. So okay. Thank you for having me. So I'm Joanne Bauer. I represent like Victory, VAgents. We are voice conversational AI for the restaurant space and other verticals, such as attorneys and anyone that could essentially use the AI for mundane tasks such as ordering, reservations, intake, reception, called fielding. So the technology is very new and we are in a groundbreaking space. So I'm excited to be here and, share what we can do to essentially save time as well as money and make everyone's life just more efficient.
And how do we reach you? Joanne,
You can reach me at, I'm sorry?
just give us your phone number or your email address.
Yeah, my phone number is 305 481 1709, and I could throw that in the chat as well as my email.
Okay. Thank you.
Thank
Matthew.
you.
Matthew, good
Hey
morning and
everyone.
welcome.
Hey guys, thank you. This has been fantastic, and that was a great presentation. Um, we're recruiters, EHS Recruiting Company. We started about 30 years ago, when recruiting was basically classified ads, newspaper ads, and this company has organically grown. We're all 1099s. You got a bunch of headhunting sharks here. We've grown to about 18 offices across the country. We've been specializing in hospitality right around 2020. Kind of before that, we started venturing out to different industries. So now we're recruiting basically in any industry. We're very hands-on. We're not using ATS or tracking systems like that. We basically go through an old school approach. We're not, I mean, we use the job boards, but the job boards, I could talk about this for hours about how they're kind of hurting themselves and how um, I'd love to discuss with Joanne about AI and how it affects the ATS systems and the people who are applying to these jobs. And are they those people, or are they just getting past an ATS system to get to an interview and then learn how to answer the right questions on the interview? We kind of go back old school, and we back in the day where anybody who's a restaurant operator would remember getting phone calls and getting calls at their restaurant from recruiters, from headhunters who would want to work another job. And we would have to call the restaurant itself. Hey, I was eating there last night. Can I talk to the chef? There was a sauce I want to know about. And then you get the chef on the line and, oh, hey, I'm a recruiter. That's 20 years ago. The tools we have now, I can just text that person directly with the right tools that we pay for. So the very hands-on approach, we're finding the people that these companies, these restaurants, these hotels, these resorts, they can't find them because they're not calling these people directly at their jobs and seeing if they want an opportunity. And if anybody is in this space, between where a lot of employees are open to opportunity, much more than before 2020. Employers are also open to opportunity to maybe drop their lowest 10% and replace a general manager or replace an accountant or something like that in their area. But we provide those services, and we can kind of really just we have now about 80 recruiters on the team, about 14 offices around the country. So we are nationwide. We're actually in Canada as well. So yeah, basically what I wrote up there, it's EHS Recruiting Company. You can reach me personally at mfreed@ehsrecruitingcompany.com. You can just go to the website, www.ehsrecruiting.com. I want to give you the phone number of the front office. Obviously, I don't know anybody who has their phone numbers on them. It's a 941-926-1990. We are in Sarasota, but obviously we have about 4 offices in Florida itself. So we're here for any of your companies, any of your candidates, any of yourselves who need kind of recruiting assistance. That's what we do, and we're on a contingency. There's no paying. It's basically just signing a contract with us, and you don't have to do anything else. We will find the people for the clients, and until they hire, they don't pay until they hire somebody. And there's also guarantees on the things we do. 95, by 95% of our 99% of our over 500 Google reviews are 5-star. We really are. We take a personal approach.
Let me jump in here for a second. I want to get everybody in.
Sorry, yeah,
So,
I
all
keep
right.
talking.
So I'm sorry. Well, thank you for coming and welcome, and we'll get to know you over the coming months. Let's see. Lily, good morning.
Hi, good morning, everyone. My name is Lily Tudela, and I am a franchise restaurant owner in Miami. I have two locations of kind of a local franchise called Giardino Gourmet Salads. Anybody from South Florida might have been there, heard of them. Yeah, I got a thumbs up. So I have, like I said, two locations, been in the business for 10 years now. And I'm actually doing a little bit of exploration into maybe a new concept. So I was invited here by Azalea to get some information and meet everybody here and hopefully start attending some of the meetings.
Well, give us your contact information. How do we reach you?
Sure. My phone number 305-773-3761. And my email is Lily, LILLYTUDELA @gmail.com.
Can you put that information in the chat also, please?
Absolutely will.
Great, thank you.
Yeah, thank you.
And by the way, there are many people in this group who can help you in your expansion plans. So,
Excellent. That's the idea. So thank you.
let's see, somebody else new but old. Carrie, good morning.
Howard, can you hear me?
Yes, now I can.
It's a pleasure to be on the call. I learned a lot from listening to Howard. My name is Kerry Miller. I am with a trade magazine called Food Industry News. I am the Howard Appel of Chicago. We produce a monthly print and digital trade magazine called Food Industry News, which reaches all the different levels of the $34 billion Chicagoland market. And then we do quarterly events for our readers and provide all kinds of support to vendors that want to do more business here in our culinary forward market. So it's an honor to be with you. And Howard, I applaud you for putting together great programs and a great networking event like this. And I can see how this really helps connect people in the market as well as giving resources to people like Lily who are growing and expanding and looking for qualified vendors that can help them on their path.
Well, it's a pleasure to have you here. Thank you.
Thank you.
Absolutely.
Okay. Anybody else that's new? I don't think so. So let's Ed, good morning.
Good morning, everybody. You caught me by surprise, Howard.
I know.
Elliot, I liked what you had to say. It was interesting. Having done some of that, long time ago, brought back some memories which were sometimes uncomfortable. So anyway, thank you. Ed Gerton with Seacoast Sales. We're an equipment supply company in Orange Park, Florida, which is just outside of Jacksonville, and we specialize in frozen dessert equipment. So we have vertical and horizontal batch freezers from BGI and Carpigiani. We have soft serve machines from Carpigiani. We have mixed treat machines, pasteurizers. We have display cases from IFI, ISA, and BGI. We have slushy machines, dream machines, hot chocolate machines. You can reach me at 904-334-4489. And we will be at the Florida Restaurant Show in booth 1745. You can come and look at us there. We'll have equipment for sale, for information, and have ice cream and gelato for everybody to eat. Have a good day.
Okay, thanks. Brian, good morning.
Good morning, everybody. Glad I didn't have to follow Chris. I don't see Chris on there anymore.
He dropped off.
Good morning, everybody. Elliot, good presentation. good insight to things. Helped me answer some questions I had over the years come across. Again, I'm Brian with Rogue Financial Group. We are a commercial equipment financing company. We will work from small to large projects. I primarily focus on the hospitality side, which is restaurants, bars, breweries, do some stuff with convenience stores. I do dabble in some other industries. And again, I work all over the country. And again, it's commercial equipment financing. And I will work with startups. And locally, I'm here in Georgia, but I work all over the country. And I'm in group 9 o'clock. And I can be reached at 404-723-7222 or Brian at rogueleasing.com.
Yeah,
All right.
thank you.
Mhm.
Azalea, good morning. And
Good morning.
thank you for bringing Willie.
My pleasure. I told her, fill your pockets with resources with these guys. So my name is Dasalia. I'm a business broker and commercial realtor in South Florida. We help clients find a commercial space. Ideally, it has already a restaurant. It has some kind of infrastructure to save you some headaches. And we also help clients buy and sell, mostly sale of assets, but sometimes a restaurant with numbers and concept and everything ready to go. My number is 786-457-2796. Thank you, guys.
Thank you. Jerry, good morning.
Good morning, everybody. Happy Friday. My name is Jerry Mangual. I'm the Director of Business Development for a company called Restaurant City. Restaurant City is a fourth-generation family business with 5 equipment superstores spanning the East Coast. We have 2 down in South Florida, 1 in Pompano Beach, 1 in Sarasota. We are definitely a equipment superstore by every imagination or meaning of the word. We have everything from stoves and burners to ranges to pots and pans and knives. Anything that has to do with a restaurant or just someone who loves to be a home chef. We're definitely stocked and 50,000 square feet of just nothing but equipment and supplies. Open to the public, no membership required. I could be reached at my cell is 954-415-3040, or my email is Jerry with a G, Gerry at restaurantcity.com. Thanks, guys.
Thank you. Terry R., good morning.
I knew you were going to call on me when my lawn guys are all close by. Okay, so I'm Terry with Creative Business Impressions, and Elliot, they always say that the more you learn, the more you realize how much you don't know. So thank you so much for educating us all. I am a 21-year veteran of promotional products industry. I do anything that you can possibly think of that you want to put your company logo on. I am doing a lot of pink this month to remind people that next month is Breast Cancer Awareness Month, if anybody's interested in helping to support that. But I can help restaurants in all kinds of different ways, everything from your boxes that John Bunn ties to banners and cups and mugs and travel mugs and napkins, all that other kind of stuff. And I work in several different industries. I've been doing this for 21 years. 561-308-1393. I'm in the 11 o'clock group, and I'm located in Boca Raton, Florida.
Thank you. Jordan, good morning.
Hello, everyone. Jordan, CEO and co-founder of Starfish here. Really enjoyed this presentation. As someone who filed a provisional patent earlier this year, it's crazy how complicated it is. So, Elliot, thank you. Really helpful, really insightful. Starfish is a software company that uses AI to help restaurants and small businesses better understand their costs and lower their costs. The way that we do that is by automating P&L analysis. So instead of going line by line, analyzing the P&L, you integrate with Starfish and we do all of that for you. You can reach me at 914-844-5775, or my email is jordan.silverman at usestarfish.com. Thanks.
Okay, thank you. Steve Geller, good morning.
Good morning. Good morning. Good presentation, Elliot. Thank you. Steve Gell, Leasing Solutions, Palisades, New York. 40 years in the industry. I have a wide range of funding sources to do a wide range of businesses, credit types, age of customers, equipment. I also do working capital, SBA loans, merchant cash advances. My number is 845-362-6106. My associate in St. Petersburg, Pam Hewitt, 813-531-0654.
Thank you. Helen and Rob, good morning. You're on mute.
Hi, everybody. First of all, Elliot, that was so thorough. It was fantastic.
Very informative.
And Howard, this is an absolutely fantastic group, very thorough. We've gotten so much information. And thank you also for the coffee connection. Bob Schiller, he's amazing. We are Delicious Spoonfuls. We're a nonprofit 501c. We train and employ people with disabilities. And we do a lot of events. We've done in the last 10 months just about 60 events. We're going to be starting to do our own events in the fall. And we serve ice cream and all different, about 6 different distributors we represent. And we're now getting into coffee as well. We will be doing, this month, we'll be doing a lot of training. We have one event coming up on the 19th at the Western Rotary Club. Actually, Western Rotary, it's the Unicorn Flavor Charity at the Rotary Club of Western Food and Wine Festival Extravaganza. It's at Temple Dorum. I can't remember the Dorum, yeah, in Weston, and hopefully we'll see you there. And that's what we do. We're also starting our annual fundraising for this month. So, you know, if you want to donate, that's your option, and it's tax deductible.
The email is helen@deliciousspoonfuls.org, phone number 561-676-2078, and it's deliciousspoonfuls.org.
Okay, thank you. Stephanie, good morning.
Gotta get going.
Hi, everyone. Thank you for the presentation. I was paying attention. All that stuff, it's so complicated. I remember learning it in school, and there's so many details, and it makes sense why, you know, it takes time to talk about it, and it's really important information, especially for people that are opening up new businesses. So again, thanks for taking the time with us today on that. But Mark and I, we're Brilliant Computers. We provide services for all things IT, software and hardware implementation and support, managed services, managed security, online backup. We're now able to even offer assistance for virtualizing server environments, taking server environments, which is, you know, where QuickBooks data is sometimes stored, or Active Directories or domain controller type environments. We're able to now virtualize those so you can access your data and your workspace from anywhere. And yeah, it's pretty amazing all the things that we can do. If you have any questions, don't hesitate to reach out. And when in doubt, reach out. If you ever get to a website or get an email that you're not sure of, send it over to us or give us a call. The best way to reach us is to email support@brilliantcomputers.com. That'll open up a ticket. It's support@brilliantcomputers.com. The office number is 561-877-1119. Thanks for having us, Howard.
Thank you. Chris, and I think Kevin dropped off. So
Yeah, Kevin had to get on another call. He had scheduled this morning. So our company is Strategic Supply Chain Partners. We function as an outsourced purchasing department for our clients. We work with them on improving distribution agreements with broadline distributors. We work directly with manufacturers to get deviated pricing or program pricing. plugged into our clients as well. We work with a variety of group purchasing organizations to bring additional save to our clients. On top of that, we can do food, we can do non-food, supplies, paper goods. We actually work with some of our clients on utilities, linen, trash pickup. There's a lot of things we can help with. The things that we don't do is anything associated with labor, things of that nature. We don't negotiate leases, but we typically save our clients between 8 and 12% on what they're currently paying. I know that sounds like an absurdly high number, but it's actually pretty easy to get to when you understand how the world of purchasing and logistics works and the caliber team that we have as well. So again, strategic supply chain partners, outsourced purchasing. Happy to talk to anybody. We've got a great referral program also. And I know that our contact information will be posted at the end of the meeting. Thanks. Have a great weekend.
Okay, thank you. Ferry, are you there? All right, we'll go to, there he is. Ferry, you're up.
Hi, so I'm here with PVI Manufacturing. PVI has been in business since 1991. We're a manufacturer storage with direct shipping through our distributor dealer network. We provide food service and restaurant kitchen solutions for restaurants and any kind of kitchen, such as pizza racks, stainless steel tables, carts, equipment stands, you name it, we can make it. Our website is pvimanufacturing.com. Or you can reach me at ferry@pviramps.com or my cell at 646-683-8456. Thank you.
Okay, thank you. John Bunn, good morning.
Good morning, everyone. My name is John Bunn with the Bunn Company. If you've ever gone and gotten a stack of pizzas or gone to a bakery shop and you have a hard time carrying your products out, they put them in bags, or like the pizzas, they shuffle all over in the back of your car. We manufacture the bun tying machine. We've been around 117 years, tying all sorts of bundles throughout the world. Today, with the problem with plastic bags, they don't work. Plastic bags have some problems with moisture. The twine works perfect, can carry the bundles, give a level of security for your food, especially with third-party deliveries, where now if you research the studies, 80% of the drivers admit to eating the food they deliver. It's quite disgusting. Stickers don't work. Bags don't work. They open them, they tear them, they use their teeth. You name it, they do it. It really is pretty bad. Cost of the twine, you're looking at 0.002 of a cent per foot. You can't get anything less expensive, and it's quick and it's easy, and the knot cannot be duplicated by hand. Give us a call. It's 1-800-222-BUNN. Our email is info@buntyco.com. That's BUNNTYCO.com. Stands for Bun Tying Company, nothing to do with Tyco. We were around long before them. That name actually dates back to the 1930s. Thank you all.
Thank you. Randy, good morning.
Hey, good morning, everybody. Randy Pumputis here with Heartland Payroll. My new favorite word, franchise. Love it. Love it. Love it. I'm actually sitting outside of the Lauderdale Convention Center. There's a franchise show going on free of charge. So anybody's interested, there's a 2-day networking availability there. You just got to go online and get your tickets. So Heartland Payroll, we specialize in startups, multi-locations, mom and pops, acquisitions, and of course, franchises. Our proprietary software handles everything from hiring to retiring. So any size client, we specialize in the hospitality industry. We can do it all through the payroll and HR solution. I can be reached at 585-622-2993. And again, the show is today and tomorrow. This is my first time attending, but hopefully I'll see some of you there. Thank you.
Okay, thank you. And TRN Terry.
Good morning, everyone. Hi, Carrie. Officially again, nice to see you. Elliot, honest to goodness, every time I hear someone talk about being an attorney, and if you mention trademark or the things that you talked about, they said, oh my gosh, no, that takes forever and it's so hard. So I just listening to what you did was unbelievable. It's crazy, but thank you. It was super informative, and I can go back and watch the video and learn what I didn't know, and just crazy. Thank you for being here. Welcome to the new people. And what I do here is my specialty is to find out what is opening in Florida and in Georgia on 2 separate reports. You get by the 9th and the 15th of every month in an Excel spreadsheet. I will let you know what's opening from the Panhandle all the way down to Key West. And our team puts everything together. I get it on the 1st, format it. You get it around no later than the 10th if you're in Florida. We guarantee now, we're at the point after 9 or 10 years, we can guarantee a minimum of 50 brand new leads every month in Florida. Randy can contest to that, and so can several other people that are in the groups. Most everyone gets them. These reports are second to none anywhere in the United States. We give you the owner's names, phone numbers, email addresses, where they're at in their construction phase, several different other items. Are they 2 and 3 stories with the rooftop bar? Do they have an outdoor area now for dogs, which is a huge deal? Outdoor bars, food truck parks, pretty much anything and everything that everybody in this group needs. And as I'm dropping things off at restaurants, Jerry, we dropped off flyers at restaurants that were under construction. Is he here? No, he's not. Whatever. Okay, so he dropped off. And the things that I've gotten from everyone, cards and flyers, those go as well. So anybody that gets any leads from South Florida, let us know. Happy to help. Anybody that wants to send me cards, flyers, as we drive around and our people drive around, we do put them in the doors of restaurants that are coming in, and there are a lot. One closes, another one's right behind it. So yes, there's a lot of turnover. However, there's a lot coming in. I can tell you that right now. Florida's right, Randy. It's just crazy. And anyways, if anybody wants a sample report without the emails and phone numbers, it's a little bit older, but it will show you the value of the report. Email me, terry@trnusa.com, or you can call 561-620-8888. Everyone have a good weekend.
Okay. I think I got everybody. I didn't leave anybody out. I know I got Ed, so I didn't leave him out. All right. If any of the new folks who came today want to add anything to what they said, raise your hand and I'll call on you. If not, I want to thank everybody for coming. I appreciate you coming. Elliot, again, thank you very much for a great informative presentation.
Crazy.
And if you want to reach us or become a member of our group, or if you're a restaurant owner like Lily, who has some questions and concerns, give us a call at 561-620-8888 or go to our website at trnusa.com. And if you want to show anybody this video, you can go through our website at trnusa.com. There's a link for YouTube on the website. So again, thank you all for coming. See you next week, and let the sauce be with you.